You're watching the second Newshour Debate on Times Now Super Prime Time.
Aryama Sundaram, Senior Advocate Sanjay Hegde of the Supreme Court as well. K Anand is with us, Kavita Srivatsav. Thank you very much. Aryama Sundaram, the court could have done more, much more. It could have referred the matter to the police. It could have placed the facts before a judicial bench of the Supreme Court. When a case has been prima facie established, then how can the Supreme Court of India leave the matter at that?
I think the court has done more than what the court could do. Let me be very frank about this. I believe that the first day when this blog came out, the innuendo was that it was a sitting Supreme Court judge, and it was an intern of a sitting Supreme Court judge when the incident happened, that the judge has recently retired, and it made it sound like the judge had retired after the incident. It made it sound that every retired judge was under the gaze, and I thought it was a very unhappy innuendo, because the fact of the matter is, whether we like to accept it or not, a person is in your jurisdiction either if he was a sitting judge when it happened, or she was an intern of the Supreme Court.
But now they have investigated and found out, for whatever reason.
Sorry, I have to.
For whatever reason, they have investigated and found out a prima facie case.
Arnab, your question to me was very specific.
Yes.
Your question to me is, do you feel the court should have done more?
Yes.
And I'm answering your question whether the court should have done more.
The
fact is, it was a person who had already retired as a judge of the Supreme Court.
Well, then they should not have even looked at the case, but they have looked at the case.
And I've retired from the company.
But that's all right.
But the company have jurisdiction. What do you expect the court to do?
Mr. Sundaram,
I have a question for you, Arnab. What do you expect the court to do?
No, Mr. Sundaram, don't put it at me. I'll tell you. See, one second. One minute.
The court have done more. What do you expect the court to have done?
1 second. That's the argument.
If the complainant doesn't come forward and give a complaint, what do you expect?
1 second.
If the complainant comes forward and gives a complaint to the police,
case,
of course, law will take its course.
Mr. Sundaram,
and FIR will be lodged.
Mr. Sundaram,
but what is the court to do now?
Mr. Sundaram, you see, let's be very clear. Your question is, what should the court do? Now, what I remember is
according to me, nothing right now.
1 minute.
And what the court has done
1
is
minute, Mr. Sundaram. Mr. Sundaram, 1 minute. It was the observation of the court, of the esteemed court, that justice will be done. Right? Now, when you have said justice will be done, A. B, you have already taken cognizance.
No,
1 minute. Allow, take the floor of my argument. Mr. Sundaram.
That was the innuendo in the blog, and it was a false innuendo.
No, Mr. Sundaram, now we are not talking innuendo.
He was a private citizen. She was not an intern of the Supreme Court, and those are the true facts.
Mr. Sundaram,
in which case, how can there be a Supreme Court panel in the first place? Where is the jurisdiction for a Supreme Court panel to look into it in the first place?
Mr. Sundaram, the question is this, that first of all, the court has taken cognizance. Now, whether you agree with the fact or not that the court in this... No, 1 minute, allow me to complete, please, Mr. Sundaram. Great regard for you, but let me complete my statement. Prima facie, the alleged crime has been prima facie established. A. B. The person who is accused is a powerful person, right? And the person who is the victim is a far less powerful person. In fact, I would say relatively a far weaker person. B. 3. The question is of high moral standards, right? After all, it's a Supreme Court judge. 4. In response to your question that it should not even be looked at as a former Supreme Court judge, well, for whatever reason, maybe because it came in the media, maybe because it was discussed.
Not looked at by the Supreme Court, but the lady should give a charge. According to me, the police should register an FIR if the girl comes and complains.
So the argument,
but she has not complained. That is the problem.
So the argument is that in this case, what the court could do, right? Let's get Kavita Srivatsav into this first. Second point of view. What the court could do is nudge, as Arun Jaitley writes in his blog, nudge the police investigating agencies into action. There are so many cases in which you refer...
Under what authority of law? Under what authority of law? In which case, Arnab, you can nudge them, I can nudge them, anybody can nudge them. Under what? No, we are talking law here.
Yeah, we are talking law.
Under what authority of law can they be nudged? Then Mr. Arnab Goswami can nudge them, Aryama Sundaram can nudge them, the whole world can nudge them. But don't
Mr. Sundaram, I'm not... Mr. Sundaram, I'm not...
input legally.
I'm not, you see, I'm not a Supreme Court lawyer. but with the greatest of respect, I'm not completely unaware of the facts in this case. You can direct the police to file an FIR. You can put it to a bench. The bench can nudge the police.
How can you? Arnab, under which provision of law?
Mr. Sundaram, you under section 154 of any information in cognizable cases, you can file an FIR as per section 154 of the CRPC. Does the Supreme Court not have powers under Article 142 of the Indian Constitution to act and initiate criminal proceedings? It has.
I'm sorry, in a case of modesty of a woman, it is only the woman's complaint which is necessary.
There are so many cases.
That's why even now, I'm sorry, you're wrong. Even now,
Mr. Sundaram, no, Mr. Sundaram.
Why is it the police are saying we need a statement? What if the woman comes forward and says nothing was done to me?
Mr. Sundaram, I don't want to limit this argument to you and me, but I think it's setting the basis for an interesting conversation. I only remember that the Supreme Court took, with rightly so, suo motu cognizance in the case of police brutality in Punjab after videos showed a woman being hit by policemen in Bihar. You consider what the Supreme Court said, and I will quote to you what the benches of Justice Singhvi and Ranjana Desai said, and I quote, "We feel it is proper for this court to take cognizance of the gross violation of human rights as well as the constitutional rights of the people. Content of the news items have revealed that members of the Punjab police and the Patna police have mercilessly beaten unarmed women and teachers. Both the incidents have shocked the conscience of the, allow me to complete, of the entire nation. These incidents raise important constitutional issues relating to Article 21, right of life of the Constitution and the dignity of the individual." Now that's suo motu cognizance. If the court could do that in this case, many people expect the court in this case, having led the way by taking cognizance, to move the next step and perhaps take the next step as well. But the court in its judgment will decide.
I'll answer your question.
No, Kavita Srivatsav, let's get your take.
See, I think the first part of the Supreme Court order led by the Chief Justice is excellent. That they have inducted the judge, that they have believed the girl. That's excellent. However, they've also dumped her and said, well, you go your way. Now, they could have done many things. I agree. They could have written that, please, NCW facilitate, or the committee constituted by the Supreme Court, you facilitate. Or they could have even gone a step further and said that the Parliament should do something about us. The judges are not extraordinary people. Till now there's no law that their conduct, which is an unwelcome advance, can be examined. Not even the new committee that the Supreme Court has put together will examine judges, because judges' conduct goes into an impeachment in Parliament. So they could have done many things. I think they could have really restored more faith in women. They could have done a lot. And also,
I don't know why.
Impeach a retired judge?
See, why is the Delhi police waiting?
You expect to impeach a retired judge?
They can suo motu.
It's not this. You see, please, Mr. Aryama Sundaram, it's not a question of retired or serving judge. Please, Mr. Hegde,
It is.
1 minute, Mr. Hegde. No, 1 minute.
I just want to get in for a minute.
Aryama Sundaram, Mr. Sundaram. Just a brief intervention, please, if I may.
Aryama, let me get in.
No, watch it. Mr. Hegde, just a brief point. Just a brief point.
Intervention is this.
Just a brief point. Can you, watch it.
Brief point is this. Where is a cognizable offence? Where is a cognizable offence?
Oh, Mister, you don't make it technical.
Shown?
Prima facie, the court has found it.
What the Supreme Court has found is unwelcome verbal and non-verbal conduct of a sexual nature.
Please, don't, Mr. Hegde, don't try now. You know, this is a very serious matter.
But not for anything which has happened in December 2012. We do not know what the lady has told the Supreme Court. She may have told the Supreme Court, I will depose to you, but I do not want to take this job further. Yes, if she tells the Supreme Court, I don't want to take this further,
one second.
Is the Supreme Court to say, irrespective of what you say, I am going to take this and dump it in front of the Parliament
Mr. Hegde, 1 minute.
And tell the policeman,
Mr. Hegde, I am only quoting here from this article which I find interesting. Mr. Jaitley writes, and this, be you ever so high as the law is above you, the Supreme Court has repeatedly told us. it must apply the same yardstick to itself. If it has found a former judge of the Supreme Court prima facie committed an offence, it cannot follow an escapist route and hold that on the administrative side it has no jurisdiction. The Supreme Court is fully empowered on the judicial side, and that is this is the moot point. The Supreme Court is empowered on the judicial side to ensure that the law takes its own course.
That is not right.
You cannot. No, can you place it before the bench of the court? Can you place the matter before the bench of the court? Possible or not possible, Mr. Hegde?
Does not complain.
No.
Arnab,
no.
Let's look. No. Arnab, I appreciate
you can't place.
I'm actually as agitated as you are.
No,
I'm as upset about what's happened as you are.
But you cannot place the matter.
Here is a case where if the girl wants to complain, of course, the moment she gives a complaint, they should take an FIR. The police now has asked her for a statement.
See, there are two questions.
If she comes forward and gives a statement, they should immediately take action.
No, you must understand the context of this. No, you must understand the context of this. You must the context is this, Mr. Sundaram. Actually, let's get Kavita Srivatsav back.
The judicial side is absolute poppycock for one simple reason. You do not file a criminal complaint in the first instance before the Supreme Court.
One second, please. Mr. Hegde.
If the police
Mr. Hegde, you can refer. Please, Mr. Hegde, just give me a minute. You can argue any amount technically. The fact is, can the matter be referred to the police or placed before a judicial bench of the Supreme Court?
Law is technical, Arnab.
Mr. Hegde, I know I am not, as I told you. You see, it is Justice Satasivam, with the greatest of respect, rightly said that justice will be done. This was said at the time of setting up of the panel.
And who are we to say that justice has not been done?
No, because today,
just hear me out.
One minute, Mr. Hegde, don't get aggressive, please. I'm not being aggressive with you.
Naming and shaming of the judge.
Naming and shaming.
There is a public naming and shaming of the judge.
No, you can't say that. You can't say. In the case of Tarun Tejpal, in the case of Tarun Tejpal,
what further can be done?
In the case of Tarun Tejpal, since it's a recent example, nobody argues that the naming and shaming of Tarun Tejpal is enough. Now, please, will you stop any investigation into the matter? They're not required. And by the way, Tarun Tejpal even stepped down as the editor of Tehelka. In this case, he's not even stepped down as the West Bengal.
Complained.
No, 1 second.
The girl has not complained.
So, in this case too, the investigation began suo moto. And after it began suo moto, the statement of the girl was recorded.
You're right.
So that is the point I'm making. If I'm right, why did you
The girl's complaint in Tejpal discloses a cognizable offence.